Yes, good evening to everybody. That today is the last day of the class on the family law, that is the Muslim law. And read what I posted on the screen. Anyone can unmute and read.
Good evening. Distribution of property of a intestate Christian as per Indian succession law. Professor Dr. Mohammed Saheb Hussain.
Very good, very good. So you read well. And this is also, read this in also.
Interstate.
Good evening, interstate. Over.
Good evening, Interstate Professor Dr. Mohammed S. Hussain.
What is the mistake I have committed here?
Good evening. Yes, Saheb.
The mistake here committed, I put the abbreviation form that Saheb, I could not write it, then S full stop right. When you see the starter of this circular bracket, doctor, B capital letter or small letter, dot, instead of keeping the arrestor, I put the hyphen. Is it hyphen? No.
Sir.
Underscore.
Understood.
I put the underscore there instead of hyphen. Instead of arrestor. So now let us come to our point of study is concerned. Yes, I already told you that, this is the point we are going to study now. And especially from the section 40 to 49, our study is today and we will wind it up. That is the distribution where there are no lineal descendants. Rules of the distribution where the interstate has left no lineal descendants. That means no father, no son, no grandson. Is it mean descendant means not father? Father comes in descendants. Are you following me?
Yes, sir.
Then why you did not make an objection? So where an intestate left no lineal descendant, the rules for the distribution of his property within parentheses after deducting the widow's share, if he has left a widow, shall be those contained in the section 42 to 48 deals about. Where intestate's father's living, if the intestate's father is living, father is a ascendant or a descendant?
Ascendant.
Father is ascendant. Yes, he shall succeed to the property. If only no descendant is there, only father is there, no widow is there, then father is going to get. Father is going to get. Father is going to get. If you don't know, say pass on.
Total share of property.
Entire share of the property because the widow is not there. If the widow is there, how much it goes to the widow? No lineal descendants are there.
1/3.
1/3 if the descendants are there. If the no descendants are there, it goes to 1/2.
1/2.
Then the father will get?
Entire.
Father will get?
1/2.
1/2. That was the thing. Now let us see, because I told you, no, I would be very thankful to the Dr. Wasim I Khan and whose things which I am using, animation. Rules of the succession in case of a Christian virgule other than Parsis. Rules of the distribution where the intestates have left no lineal descendants, section 41. When an intestate has left no lineal descendants, the rule for the distribution of his property, within parentheses, after deducting the widow's share, if he has left a widow, shall be those contained in the section 42 to 48. It deals about. Now let us see what is the 42 says. If the intestate father is living, and he shall succeed to the property. Suppose, see, here father is there, and a widow is there, and how many lineal descendants?
3.
3. There is no lineal descendants. Into is there now?
No, sir.
Then why you are saying 3? Say no lineal descendants live. So how much the property goes? I told you now, when the lineal descendants, widow will get half share and father will get
Half share.
half share. There ends the matter. Now let us see that. Suppose if the lineal descendants are here. Now you tell me. Yes? Why you are looking at me? A simple logic, what we decided? Near relatives eclipse the far relatives. Are you following me? Are you following
sir.
me?
Widow half, sir. Widow 1/3, sir. Linear descendants total 2/3.
Then 2/3 into 3. Father will be excluded or not excluded?
Father will be excluded, sir. Widow
Why?
will get 1/3.
Why father will be
And
excluded?
near relation will exclude father relation.
Do you think the father is a first degree relation or second degree relation?
Second
First
degree
degree.
relation.
Who said father comes in the first degree only?
First degree, sir.
Then what about the children? Actually, when your lineal descendants are there, generally, of course, they will also be father also be considered. Let me see in the next thing. Now, no widow and no lineal descendants. The entire property goes to. But if the no widow, then lineal descendants 3. Then how the property will be shared? Generally in Christianity, they say equally decided. Equal. See, father is 1 share and 3 children are 1 share, means 4. 1/4, 1/4, 1/4. That is generally the followed over there. If such a thing comes. Now let us see rules of succession where the intestate's father dead. Okay, no more father, means no ascendant, but his mother is there. Brothers are there and sisters are there living. Section 43, how it can work. If the intestate father is dead, but the intestate mother is living, and there also brothers and sisters of the intestate living, and there is no child living of the deceased brother or sister, the mother and each living brother or sister shall succeed to the property in equal shares. See, I told you, no, in the Christianity, where the same class would be there, they will get the equal shares. Unless if the first degree is there, second degree is there, then the first degree will eclipse the second degree. When the father is there, then father will be eclipsed with the grandfather. But father is there, lineal descendants are there. At that instance, no, everybody get the same share. Like suppose father is there, now here the mother is there, and lineal descendants are there. How it can be distributed, you can see here. See, mother is there, okay. Then brother is there, okay. How many brothers are there? 2 brothers are there.
1 sister.
1 sister is there, okay. What about the lineal descendants?
No lineal descendants.
No lineal descendants. Now, how many are shareholders here? Surviving people? 4. Number 1, 2, 3, 4. So, equally they will share it. Mother will get 1/4, and brother will get 1/4, and this brother will get 1/4, and this sister will be 1/4. Suppose, if this brother dies and are having the 2 children, then stirrups will succeed. 1/4 will be shared by the 2. Suppose Two children are here. 1 by 4 into 2, 1 by 8, 1 by 8, they will share it. Is it clear?
Yes, sir.
Very good, very good. So now you explain this thing in terms of the words. Anyone? You explain this thing, the graphic in terms of the words.
If
Yes?
the propositors
You don't say
dies,
propositors, intestate dies.
if a intestate dies, if he has mother, two brothers, and one sister, and he has no lineal descendants, then mother will get 1 by 4. Two brothers will get 1.
No, that is not the way. When the testator dies without leaving the will, there are no linear descendants, but two brothers, one sister is living. In the ascendant, mother is living. At that instance, the shares, total shares are 4. All the 4 will be equally divided. That is the way of saying. See what it is given here. If the testator's father is dead, but the intestate's mother is living, and there are also brothers and sisters of the intestate living, and there is no child of living of the any deceased brother or sister, the mother and each living brother and sister shall succeed to the property in equal shares. Did they say 1 by 4? Did they say 1 by 4 here?
No,
No.
sir.
If the 3 are there, automatically, suppose if the
Equal.
sister is not there, then how many shares
1
are
by
there?
1 by 3.
3 are there shareholders. When 3 are shareholders, equally sharing means 1 by 3.
1
Don't
by
say 1 by 3. 3 shareholders are there, but the 3 would be there equally shares. That's why 3 will get 1 by 3, 1 by 3, 1 by 3. That is the way of saying. Okay, now next, let us see the 44th section. Where intestate's father dead and his mother, brother, sister, and children of any deceased brother, sister living, section 44, distribution says. How? Read. Anyone can read?
If the intestate's father is dead, but the intestate's mother is living, and if any brother or sister and the child or children of any brother or sister who may have died in the intestate's lifetime are also living, then the mother and each living brother or sister and the living child or children of each deceased brother or sister shall be entitled to the proportionate equal shares.
Property in equal shares. This is the theory. Now the theory will put it in the graphics. Here I repeat it. Is it 44 only we read it? Yes, the same. I repeated here. Okay, no matter. Because the property is closed over there. That's why that I made it here. So then the mother of the each living brother or sister and the living child or the children of the each deceased brother or sister shall be entitled to the property in the equal shares. Number 1. Another point, such children, if more than one, taking an equal share, only the shares which their respective parents would have taken if living at the intestate's death. Suppose if one of the brother or sister died over there, but they are having the children, at that instance, whatever the share comes to the father as per the strips, it will be shared by the equally the sons of the deceased brother or sister. That is, now we will put it in. Now you tell me. Rishita, read. Give the explanation.
When intestate dies and his mother, a brother or sister, and the children of any deceased brother or sister living, no lineal descendants, the property shares among themselves equally.
How many shares are there here?
4.
You have to read in this way. When intestate dies, surviving is the mother and two brothers and one sister, but later on sister died, leaving one child, but the intestate doesn't have a living descendants. At that instance, there are only mother 1, brother 2, next brother 3, next sister died. In her share, automatically it will devolve upon the child of the sister. So, how many are there total shareholders? 4. Then the 4 will equally distributed of the intestate property. That means when the shareholders are 4, mother will get 1/4, brother will get 1/4, next brother will get the 1/4, the sister she should have to allow, she would have to get 1/4, but she died, and her, as per the strips are concerned, it will goes to the surviving child, the boy, 1/4. That is the explanation. Is it clear?
Yes, sir.
Very
Sir.
good. Very good. Suppose the sister is having the 2 children here, then you tell me.
5 shareholders.
By 8, 1/8 each, sir.
1/8 and 1/8 equally share the 1/4. Are you following me?
Yes,
Say
sir.
yes.
Yes,
See,
sir.
when there is no lineal descendants, in all the places there is no lineal descendants. Are you following me? Say yes. Yeah, now the same thing which I told just before. Yes, explain. Read and explain.
If intestate dies, if, he leaves he has one mother, 2 brothers, and 1 sister, but later on the sister died, then leaving 2 children, then the property is devolved among mother, 2 brothers, and sister in equal shares, that is 1/4, and the sister share will be devolved upon the children as 1/8 and 1/8.
You committed a still mistake. When the intestate dies, leaving the mother and leaving the brother, 2 brothers, 1 sister, but later on the sister died before the intestate. At that instance, but having the 2 children, now how many shareholders are there total? Total how many? 4 only, if the sister is alive.
4 only.
When the sister is alive, 4 shareholders, hence mother will get 1/4, and first brother will get 1/4, the second brother will get 1/4, and the sister would have to alive, she would get the 1/4, but she is not alive, but having the 2 children survived, hence 1/4 is equally divided between the 2 children. That means children get to 1/8 and 1/8, and the rest of the other shareholders get 1/4 and 1/4 and 1/4. Mother will get 1/4, first brother will get 1/4, and second brother will get 1/4. That is the explanation. Is it clear?
Yes, sir.
Yes, sir.
So now, rules of succession, where intestate's father dead, okay, father is no more, his mother is living, mother is there, and no brother, no sister, no nephew, no brother, sister, nephew, or niece, whether they are present or not present. If the intestate's father is dead, okay, but the intestate's mother is living, good, and there is either the brother, nor the sister, nor the child of any brother or sister of the intestate, the property shall belong to the mother only. Means nothing would be there. No one is there. No one is there. Then entire property goes to whom?
Mother.
How much?
Mother.
Entire property.
Entire property, you say. If the property is 1, the total 1 goes to the mother. Is it clear? Now you explain. When the intestate dies, surviving
Mother
When
and
the
no brother,
intestate dies,
sister.
okay, Sai Srita, you speak now. You read.
When intestate died, but his mother alive, and no brother, no sister, nephew or niece, the entire property goes to mother.
When the intestate dies, surviving with the mother and no brother, nor brother children, nor the brother's children, no one descendant. Here, who are the descendant actually? These people are descendant. No, there is no descendants here. At that instance, the entire property goes to the mother. That is the thing. So next 47 is where the intestate has left neither the lineal descendant, nor the father, nor the mother, the property shall be divided equally between his brothers and sisters, and the child or children of such of them as they have died before him. Who has to die? The brothers or sisters should have to die before him. Him means who? Him means who?
intestate.
Intestate. Such children, within parentheses, if more than one, taking an equal shares, only the shares which their respective parents would have taken if living at the intestate's death. Strips. Now, graphical presentation. Yes, Himabindu, give the explanation.
If intestate dies, if he has two brothers and one sister, he has no lineal descendants, then the property is divided among, and as they are three shares, the property
Three
goes to them as
shareholders.
three shareholders. The property divides among 1/3 each. 1/3, 1/3, and 1/3.
That is the way. Two brothers, first brother 1/3, second brother 1/3, and the sister also 1/3, because the intestate doesn't have the lineal descendants. Okay? Suppose if she dies, we already seen two children, they will get 1/6 and 1/6. So suppose if she dies, now only one daughter is there, child is there. Then as far as the strips are concerned, as if she was alive, the share of the mother will pass on to the
Daughter of the mother.
children. Child. One child, 1/3. If the two childs are there, then how much they will get it?
1/6, 1/6.
Yes, that is the thing. So now the two are here. Now, see, I have shown two. Then automatically 1/6 and
1/6.
1/6. Okay. Now let us see the 48. Where intestate has left neither lineal descendants, nor parents, nor brother, nor sister. Then section 48 what says? Where the intestate has left neither the lineal descendant, nor parents, nor brothers, nor sisters, his property shall be divided equally among those of his relative who are in the nearest degree of kindred to him. First class, second class will come here. Rishita, explain.
When intestate dies, neither lineal descendants
Surviving
nor
with
parents, surviving with a grandmother, grandfather, nor brother, nor sister, the entire property will be divided between grandfather and grandmother.
no. When the intestate dies, leaving the two grandfather and one aunt and one uncle. Uncle photo is not there. And down who are there? No, that fellow is intestate. That fellow is intestate. Are you following me?
Yes, sir.
Yes, sir. He's intestate. His father died.
If the father died, then only the grandfather will come. Suppose the father is alive, then the grandfather will get the money. Nearest will eclipse the
No.
Father.
far away relatives. Means father is no more. Hence the property is going to the grandmother and grandfather. So now you tell me the degree. What are the degrees are here? First degree relatives, first class relatives. Father is the first class. Agreed?
Yes, sir.
Okay. But father is the second class. Agreed?
Yes, sir.
But the uncle and aunt is a third class. Third degree.
Sir.
Agreed?
Sir.
Agreed or not? Uncle, aunt, niece, they're all come under the third degree. Third class heirs. Third degree. So second degree will eclipse the second
degree.
degree eclipse the
Third degree.
third degree. That means who are excluded?
Aunt and uncle are excluded.
Auntie and uncle are excluded. Then who are going to get it?
Grandmother, grandfather.
There are only
Half.
two. There are only two shareholders. Hence, each will get
1/2 and 1/2.
equally. That means 1/2 and 1/2. Is it clear? Father is the first degree. Grandfather is the second degree. Uncle, aunt, niece, daughter-in-law is third degree. Hence, when the second degree is there, they will eclipse the third degree. They will be excluded. Only two shareholders are there. The two shareholders equally divided. If the property is 1, the equally divided means 1/2 and 1/2. Is it clear?
Yes, sir.
Yes. Very good.
Sir,
Now,
grandfather and grandmother are descendant or ascendant?
no, they are the upper level. No, upper level means ascendants. Upper level ascendants, lower level descendants. Okay, now you explain, Rishita. Of course, Himabindu or anyone, no matter.
If intestate dies, he has no father and no grandfather. He has great grandfather and great grandmother. He has aunt and uncle. Then his share is devolved among the as the great grandfather and great grandmother comes into the third degree, and aunt and uncle also are the class 3 heirs. Then the share will be equally distributed among these four. Great grandfather will get 1/4, great grandmother 1/4, aunt will get 1/4, and uncle will get 1/4.
I appreciate. Now you have not committed a single mistake. Anyway, you stumbled here and there, but did not commit a mistake. Did not, because all are in the third degree. Because father is the first degree, grandfather is the second degree, great grandmother and great grandfather is the third degree, and uncle and aunt, niece, and daughter-in-law are also third degree. So how many? 4 are there, the shareholders having the same third degree. Hence, the property is 1. The 4 will be divided. That means each will get 1/4. Great grandfather 1/4, great grandmother 1/4, aunt 1/4, uncle 1/4. That is the level. Okay, now Rishita, explain. Yes.
When intestate dies, great grandfather also die. He has a uncle and brother died. Nephew is alive. Great grandfather is also alive. There are 3 shareholders that distributed among themselves equally.
What is their first class heirs? Who are the first class heirs?
children,
Great
son, mother, daughter,
Uncles comes under
uncles comes in a
Third.
third degree, class
Third
3,
head.
class 3. Great grandfather,
the class 3,
then what about nephew?
nephew, class 3,
Class
sir.
2.
I already told you, nephew, niece, daughter-in-law, they're all come under the third degree, third class. Then all are in third class, mean third degree. How many are there total?
3,
The property is 1. Then how much they get the equal share?
1 by 3 each.
1 by
One.
3, great grandfather, 1 by 3 is uncle, and 1 by 3 is nephew. That is the thing. Thank you. So this is the total of our study. We did it from tomorrow onwards. Bye bye, and work for that lot. If any doubt comes, that you can call me. Then we will discuss if it is such a need would be there. So with this, I would like to wind up my today's class, and this is the section. But 49th, I would like to tell you what is 49th. Children's advancement are not brought into hodgepodge, where a distributive share in the property of a person who has died intestate is claimed by a child or any descendant of a child of such person, no money or other property which the intestate may, during his life, have paid, given, or settled to or for the advancement of the child by whom or by whose descendant the claim is made shall be taken into account in estimating such a distributive share. I don't know whether you got my point or not. This, if you read in this way, at least I also read at least 3 or 4 times, I could not get anything. But later on, when I, with a cool mind, I read. When I read, I understood. Okay, I will give the explanation to you. What happened in this case law? Suppose the intestate has given something when he was alive to the children who are the legal heirs. Okay? He has given to the child when he is alive something or advance given to the child. Okay? After the death, whatever the amount or whatever the property which is given him when he was alive, that will be deducted. Yes? That will be deducted when the property share will be there. Yes? Are you following me what I said? Bhaktullara,
Yes, sir, but little bit confusion.
at least say, sir, we are following, or we are keeping quiet means I don't know whether you are hearing me or not. Testate, when he is alive, he gave some property to the one of the child. When he died, intestate, can whatever he given at the time of the alive, can it will be deducted when he's getting the share? That's my point. So here also they said the same thing. Where a distributive share in the property of a person who has died intestate is claimed by a child, it is claimed by a child or any descendant of the child, either by child or any descendant of the child. Of such person, no money or other property, which the intestate may, during his life, have paid or given or settled to for the advancement of the, as advance he has given of a child, by whom, by whose descendant, either to the child or child descendant, the claim is made, shall be taken into account in estimating such a distributive share. Is it accountable or no accountable? They said no money.
Accountable, sir.
Huh?
Accountable.
Not accountable. When he is alive, whatever he has given, either to the descendant, either to the child or the child descendant, such person no money or other property which the intestate may, during his life, have paid, given, or settled to for the advancement of the child, means no money, no property, means it will not be counted. Is it not? By whom or by whose descendant the claim is made shall be taken into account in estimating the such distributive share. No money, no property means is it accountable or not accountable?
Not accountable.
See, if I give the statement, no pen, no calculator, no handouts, no smartphone will be allowed in the examination hall. That means, can we take those things in the examination hall?
No, sir.
No.
I put no. No electronic gadgets, no smartphone, no notebooks, no textbooks will be allowed in the examination hall. Means will be allowed in the examination hall means it will be allowed in the examination hall or no?
No.
The word
No.
first I put no. No money or other property which the intestate may during his life have paid or given or settled, it will not be countable in the hodgepodge. I read at least 5 to 10 times this thing to understand me, myself only. When I put the no means, nothing will be countable. No means no. Who said? Amitabh Bachchan. In which movie? Sir, we did not see the movie. Even I have forgotten, but I saw the movie, but I forgotten them. Because he is having a young lady has fallen in love with this father. So that was the movie. I don't know what is the name of the movie. So no means no
No.
only. Yes. So that is the 49th. That's why we did not discuss it here. But with this, I will play the Janagana Mana now. Let me stand. I will make it Janagana Mana. Yes. Let me we will national anthem will play. Janagana यक जय हे भारत भाग्य विधाता मराठ मराठा द्राविड उत्कल बंगा विंजय हिमाचल यमुना गंगा उत्कल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाये तव जय गाथा जनगण मंगलदायक जय भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे Jai Hind. With this, I will end out my today's class. Bye. See you. If any doubts are there, you can ask me whenever the such a time comes over there, or you can call me. With this, I will end up your meeting.